Protesters often complain about the police power Section 50 of the Police Reform Act 2002, which is the police power to ask you for your name and address during a protest. Section 50 states this: if a constable in uniform has reason to believe that a person has been acting or is acting in an antisocial manner, he may require that person to give his name and address to the constable. And Section 50 goes on to say, any person who fails to give his name and address when required to do so, gives a false or inaccurate name or address in response to a requirement, is guilty in offence and shall be liable to summary conviction to a fine not exceeding level 3 on the standard scale. According to Section 2 of the Antisocial Behaviour, Crime and Policing Act 2014, antisocial behaviour means conduct that has caused or is likely to cause harassment, alarm or distress to any person, or conduct capable of causing nuisance or annoyance to a person in relation to that person's occupation of residential premises, or conduct capable of causing housing related nuisance or annoyance to any person. Protesters often complain about Section 50 and 4 mentioned here. The first criticism is the legal test for the use of Section 50 is very unclear, allowing it to be used in an arbitrary manner by police officers by being able to rely on terms like reason to believe and antisocial manner. The second criticism is Section 50 is being misused by the police officers against lawful protesters as a way to gather information about them by being required by police officers to give their name to the police officer when they have not been involved in any antisocial behaviour or wrongdoing. The third criticism is Section 50 powers are being used as a condition or threat that they, as a protester, can't leave a location until they provide their name and address. This practice could be unsafe for protesters who may be subject to being kettled in. And the fourth criticism, arguably the very idea of protesting by nature, is antisocial to some, and so can be used against any protester, from those shouting in the street, blocking a vehicle, lying on a road, or putting up a placard. And there's been a number of recommendations to change Section 50, and 3 mentioned here. Firstly, there should be greater public scrutiny about the use of Section 50 via force-wide communication of its use and via community police panels to check for any abuse and misuse. The second recommendation is the legal test to apply Section 50 should be tightened. Consider terms like reasonable grounds of suspicion rather than reason to believe. Use terms like violent offence rather than acting in an antisocial manner. And 3, a more fundamental recommendation is to abolish Section 50 altogether, which seems to many as a simple intelligence gathering exercise. If a protester has committed an offence, then the argument goes arrest them for that, rather than demand they give their name and address. So the general advice is this: consider asking the police officer under what law they are acting under before you give any information. Simple rule: if you know the law, then you know your legal rights and legal responsibilities. You also know the police officer's legal powers and their limits. But in the case of Section 50, you know you're required to provide your name and address, assuming the legal test has been met. And if you believe the actions of the police officer was unfair, irresponsible, discriminatory, then consider making a formal complaint to the Chief Constable in that police force. Thank you for watching. Please subscribe to Community Legal Education so you can be the first to watch these short legal video explainers on police powers and many more. Please check out our website www.clevideos.co.uk for more legal information. Remember to speak to a solicitor if you need legal advice, and may the justice be with you.